Welcome to Resource Law and Regulation with Peter Scott.
Welcome to Resource Law and Regulation with Peter Scott. Peter is the founder of Scott Law in Bozeman, Montana, where he represents landowners, businesses, utilities, and local governments in matters involving water rights, land use, and natural resource regulation across the region. On this show, we break down how those legal systems actually work in practice. I'm Shameika Rhymes, and in today's episode, we're discussing access disputes in Montana, including how legal access is established, what happens when it's unclear, and how these conflicts are resolved. Welcome back, Peter.
Thank you, Shameika. It's very nice to see you again.
It is good to see you. Well, Peter, what does it mean for a property to have legal access, and how is that typically established in Montana?
Well, most commonly, when you're creating a land use, say a subdivision or something, there will be a process called dedication, and it will involve the surveying and establishment of roadways that will be typically turned over to the local jurisdiction, whether it's the city or the county. Sometimes they are managed through what's called a rural improvement district, but the basic premise is the same. A surveyor lays out where the access points are going to be. They make sure that all of the lots created and businesses that are going to reside there or homes each have access to those roadways, and then they turn them over to whichever entity is going to manage them going forward. The other way is, I'm sure we're going to talk at some length, through an easement process, also very common.
Well, how do situations arise when a property ends up without clear legal access?
Well, a number of ways. One of the big topics around here at a large scale is the checkerboarding of public lands. So when the federal government gave lands to the railroads at the turn of the last century, they created a checkerboard effect. And there's lots of litigation and ongoing legislation about what rights the public has to access public land that has these that are isolated except from the corners. Can you walk across? They call it corner crossing. Can you walk across a corner? And that's a big topic, and we're all paying very close attention to it. I think there's some 8 million acres that are landlocked through that process. That's probably not what most viewers are tuning in to look at or think about. Usually a landlocked parcel is created as some kind of a remnant, or occasionally a person subdivides off a parcel or creates through a process we call exempt segregation. They create a parcel and they don't lay out the access. It's not recorded anywhere. And then ownership passes down to some successor who acquires the property and then either does it knowing that it doesn't have access and hoping to get it, or occasionally they acquire the property not realizing that there's no legal way in. There might be a perfectly good-looking road that goes to the property only to find out it's private and does not benefit the parcel that you're trying to get to. There's a number of other ways. I've seen access issues arise because counties have, through a petitioning process, have eliminated a public right-of-way or public access, and then it's left to private arrangements, and those sometimes result in disputes. So any number of ways.
Speaking of disputes, what types of disputes tend to come up between neighboring property owners over access?
There's a joke in here somewhere. I used to talk about the fact that men of a certain age get kind of territorial, and a lot of the disputes I see seem to fit within that stereotype. Unfortunately, now I'm a man of a certain age driving a F-150 with a topper on the back, so I need a new stereotype. But I'm only half joking. It's often a landowner who objects to a certain use that's either being made of a property or is proposed. So you might have a driveway across somebody's property, and you're going to your property and everything's fine. A new person moves into the property and doesn't like that. Often it's the change in property ownership that pushes people into dispute. Another circumstance could be, I may have the right to drive across your property, and I've used it as a driveway, but now I want to subdivide my land and build 10 more homes. And suddenly what's been used as a driveway starts to look a lot more like a public right of way or a road. And you may be willing to let one home cross your property, but now we're talking about 10, and that increased intensity in use triggers a lot of disputes.
I can only imagine. So, what legal paths are available to establish access if a property does not have it?
Well, there's several. We're really talking in the realm of easements here. You can purchase an easement and have it surveyed and recorded. That's what we would call an express easement. If anytime you're dealing in a property transaction, you want to have a good handle on easements and access rights. So, very typical process in a land transaction to go through a title commitment proceeding and have a title examiner figure out where the easements are. Often you'll get legal counsel involved to tell you what's allowed or is not allowed using those easements. If you're trying to obtain an easement and the person is unwilling to sell, in some circumstances, there's a device called easement by necessity. It requires some specific facts. If you sell me a piece of property without legal access and then refuse to allow me to cross your property to get there, so we're the buyer and the seller and you sold it to me, courts are going to presume that you intended for me to have access. And they're going to enforce that. They're going to make, unless the agreement specifically says we're selling this to you as is with no access, in which case I took my chance, and that's tough on me. There are some mechanisms where obtaining access can be done with government authority or delegated authority to some other entity to condemn. The process of eminent domain can, in some circumstances, be used to create access. Another device, and I think we'll talk about this some more, is the process of prescription. This is, or sometimes called adverse possession. That's a process where you make use of the property over a period of time, and then through that use, establish a legal right to use it as access. So if I've been crossing your property for 10 years and you didn't give me permission, in fact, you told me not to, and I just kept doing it, it depends on jurisdiction. In Montana, 5 years of continuous and notorious uninterrupted use is sufficient to create prescriptive rights. And then you'd go to court and ask the court to quiet title and award you that access. And that judgment can be recorded and is then a legal access to the property. So quite a few different ways to get there. None of them are easy or guaranteed or cheap, but those are the tools that we have.
So, how do courts evaluate claims involving access rights or disputes between landowners?
Well, they're going to do it through the evidence generally. In the case I just described, if there's or an instance where there's an express easement, there's a recorded document, and the dispute is what I said before. Is it a driveway for one residential unit, or is it a road and the owner can make any use of it they want that would be consistent with a road? And so the courts are going to look at the language of that easement. That's going to control. And what was the intent of the original parties? As I mentioned before, these disputes often don't arise between the original parties. They know what they intended and they're usually in agreement. It's the subsequent owners that start to get in disputes over what was intended. So courts will just go back to the original document, make a determination about what it allows based on the plain language of the easement. If the plain language covers that use, they're going to rule in favor of the use. If it's an expansion of the use and the court concludes that it's not intended, then it's likely to be denied. That's the primary dispute that courts resolve. Some of these other areas involving things like road improvement districts, public rights of way, dedication, those disputes are often over what's allowed to be done. We built a dirt road. Some people want it paved, others don't. They get into a dispute. Some want to pay for it. They think it'll improve their property values. Others don't. So, there's a range of disputes. And in those cases, again, the court's going to go back to the original documents. And if it contains language that supports the improvements that are being sought, they're likely to agree and allow it to go forward.
So, how do easements come into play in resolving access issues, especially if there's no formal agreement that exists?
Yeah, that's largely the instance I was referring to as prescriptive rights.
Hmm.
In those cases, it's factually driven. You know, I mentioned some of the factors. It needs to be adverse to your interest as the owner. In other words, adverse to your title. If you give me permission, then it's not adverse, and I can't satisfy that requirement. But if you tell me to stay off your property and I keep driving across it, or I just use it openly and you never tell me not to, then I can make the case that I've used it adverse to your property interest. You knew about it. I did it continuously for the period of 5 years, and I should be allowed to continue. Now, one thing there, the scope of my use is going to be limited to the use I made of it. So, using that as the example for this single family home that wants to build 10 more homes, if I've been using it as a driveway for years and years without an express easement, and now I want to build on it, I think a court's going to take a dim view of that. It hasn't been used as a roadway for accessing a subdivision. It's been used as a driveway for accessing a single family home. And under a strict interpretation, as I understand it, that's what it's going to be limited to in the scenario of a prescriptive easement. So, said another way, if I went to court to quiet title in a roadway and I'd only used it as a driveway for the 5 years, it's quite likely a court would say no to that. That's an expansion in the scope of the use, and it's typically not allowed unless there is an express written statement that covers that increased scope of use.
Well, can you walk us through an example of an access dispute where the outcome depended on how access rights were interpreted?
Sure. It kind of builds on the same one. There's many examples. This is kind of a bread and butter subject for a land use attorney. Disputes arise all the time, and I deal with easements almost daily. Um, the one example that kind of fits your question, it really is very similar. The easement was granted for the purpose of transporting logs. It was a forestry easement. It was issued for the purpose of transporting logs across the property. It was narrow. It didn't meet the requirements for a county right-of-way. And the only thing it had ever been used for was forestry logs. In the course of time, that forestry property was sold to a development interest, and they had another access that did meet county requirements, but one of the county requirements was for a secondary point of access. So the developer pointed at this forestry road, 2-track, and said, there's my emergency ingress, egress, that should satisfy you. And the landowner didn't agree that it could be used by the public for residential purposes. So we went to court, and the judge looked at the language and concluded that it just said road without limitation, and granted the developer the right to use it for purposes unrelated to forestry. And that's an example of the plain language controlling the outcome. And so what I like to do in these easement questions, when I'm asked to draft an easement, we want to do them expressly, we want them recorded, and we want them to define not just what is allowed, but my preference is to include what is not allowed, to define the allowable future scope of it in terms that can't be amended or argued based on some perceived ambiguity in the text of the easement. So that's something to look for when you're acquiring property that is either burdened by an easement or is benefited by an easement. What does it allow and what does it not allow, so that you have a clear understanding of it. Very common in a transaction of that kind for the buyer to say, look, I have some other things in mind. For example, I'm going to want to be able to run on this road or ride my bike. Doesn't say that. I'd like to amend this easement to make that clear. And those are points of negotiation. So get the easement. If there is no easement, get one, get it written. Don't rely on future arguments and hoping to find someone that knows things about what happened. And then reduce it to writing and get it recorded so that your property is protected either as the burdened one that people will be driving over or as the benefited one that's using that easement.
How do access issues affect property value or the ability to develop or sell land?
Well, they have a strong influence on all those things. If you don't have adequate access, if you have a easement that's not recorded,
Hmm.
or you have an easement that's very limited in scope, that's going to potentially control what can happen with that land. Building on the same example I've been discussing, if I bought my property with a single family residence with the expectation of subdividing it later and developing it into 10 lots, and I didn't evaluate that easement, and it turns out it's a driveway, not a road, then I've been severely limited in my plans for that property. So it's something to be careful about and clear up at the front end and not assume you can make those decisions later because the other people are likely to disagree with that.
Well, thank you, Peter, for walking us through this today. This has been super informative.
Well, it's my pleasure. Thank you for having me.
Well, that is it for today's episode of Resource Law and Regulation with Peter Scott. If you'd like to learn more about Peter Scott and his work helping clients navigate land use, water rights, and natural resource law in Montana, you can visit scott-law.com. Thanks for listening, and don't forget to like, subscribe to the show, and share this episode with someone who might need it.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.